With me today is Justice Kamaljit Singh Garewal. He was a judge of the Punjab and Haryana High Court and also a judge of the United Nations Appeals Tribunal for about 3 years. He has written extensively on the issue that we're going to discuss today, that is the 3 criminal laws. Thank you for joining us, Justice Garewal.
Nice to be with you. Thank you very much for calling me.
As a first thought, what is your take on the 3 new criminal laws? Are they new wine in old bottles, or will they really help in bringing about or improving the criminal justice system?
Unlikely to have much impact on the system, because the flaws of the system have not really been addressed. And it is just introducing a few reforms which could have been done with the old laws through amendments. And what they've done is a complete renumbering of the old laws and change the heading, but it is still the same old code. What we are missing out is that it is very strong police system, but very weak prosecution system. So therefore, the prosecutions don't succeed and people get acquitted. So that is itself a travesty of justice. So they want to keep on making stronger provisions, but you need quick trial and a quick verdict, and certainly many more convictions. Otherwise, what you have done is you've kept a man in the system for about 2, 3, 4 years, and then you declare him innocent, and you've destroyed his life. So that is not going to change.
What do you think about the way they have been brought about without proper debate, discussion, and even training of the officers?
Absolutely. You see, this is a justice system. And you should have got judges to discuss on the basis of their evidence, on the basis of their experience, and how much work people who have done in the trial courts and in the high courts. You should have got them to go through these suggestions and come out with the final draft. I don't think that was really done. It is also very strongly police-oriented system.
Yes, please go on.
Which is not justice.
Okay. In some quarters, especially in the southern states, there is some resentment on the Shuddh Hindi names that have been brought about in the new laws. Do you think simpler laws would have done better?
There would be. You see, it is very difficult now to... there are states where they speak Tamil and Telugu and all. They don't understand Hindi. I mean, it's alien to them. But it has been enforced there as well. It's quite a silly thing to do, I think. They could have done a much better job if they were really intent in improving the system. And if they had had more debates, then more worthwhile suggestions would have come forward and would have helped to improve greatly.
Now, Justice Garewal, coming to the specifics of the 3 laws, there has been a demand for some years now to abolish capital punishment, death sentence. But in this case, death sentence has been added to more offences. Similarly, life sentence has been added to more offences. Do you think this is a retrograde step? Because in one of your write-ups, you had referred to the time, the regime of Maharaja Ranjit Singh, where there was no death sentence.
Yes, there was no death sentence. He never hanged anyone. He made things difficult for the wrongdoer by taking away his property and making him pay for his wrongs to the victim. But there was no death sentence. That is true. And there is no death sentences. Large number of cases, countries now. European countries don't have death sentence. You can't become a member of EU if you have death sentence. So you have death sentence only in USA there is, And of
Right.
course, in Russia and China and other countries, and of course, Islamic world, I think they still have death sentence. But death sentence doesn't. It should be abolished. As a
I think
judge, I never wanted death sentence.
this is what I think the Law Commission's recommendations are, and even the Supreme Court has
Yes.
perhaps said that it should be in the rarest of rare cases the death sentence should be awarded.
See, they keep going back to rarest of the rare cases, but even in a rare case, even a gruesome crime, if you lock up a man for life, that's fine. I mean, you've finished him off anyway, but he's still alive, and there is still a chance, a remote chance, that some evidence emerges, which might show that either he was innocent or there are some mitigating circumstances. So once you hang the person, then that chance is gone. And secondly, you don't even execute quickly. The process goes on and on and on. So many years people have to wait in the death row before the final execution takes place. That itself is extreme cruelty. You want to hang the person, then please do it quickly. That also is not done. So there is a big debate going on. In India, we are still sticking to the view that death sentence is only the rarest of the rare cases.
You
But
had
still,
referred to, in your write-up, one of your write-ups, you had referred to the system during Maharaja Ranjit Singh's time. They had
Right.
something called Nazrana, you said, and then Jurmana, Harjana, and then
Yes.
Taikhana, but no fancy.
Yes.
So how did the system work?
Well, Nazrana is when a person appeared before the Nazam, he had to pay some sort of a fee for his case to be decided, to be
Okay.
heard, and then that is Nazrana. And then when he is found guilty, then Jurmana. Then Harzana is the compensation. And then finally is Taikhana. That is, he is locked up for a certain period.
Taikhana
But
would be akin to life sentence now, right?
yes, would be life sentence. I'm not really sure how it worked,
Ji.
but Taikhana would be in the dungeons and lock up the person in the dungeons.
Right. Now, coming to another aspect, there is a feeling amongst a lot of legal luminaries that the police has been given more powers under the new laws, and the police could use these in an arbitrary fashion. Would you agree with that?
You see, the basic constitutional principle is that within 24 hours of his arrest, the person has to be produced before a judge.
Right.
After that, he is under the judicial umbrella. And the judge should be more proactive and in watching the interest of the accused, that he's not tortured, he's not treated illegally in a fashion which the law doesn't permit. So if police is strong, fine. I'm okay with strong police, but I want to see strong prosecutors who will stand against the strong police.
Right.
And the police does not look up evidence or plant evidence, and then the prosecutor looks the other way. And finally, when the case comes to court, after a few years, it ends in acquittal. So that kind of system is very harmful for our society.
There is
We
an
should have a
addition.
strong prosecution.
There is an additional clause that provides police to get a 15-day remand out of about custody
Yes.
of 40 to 60 days. What is your
Yes,
experience?
that's what-
You've been a judge at various
There
levels.
is, there is
How does this
no
work?
need for this. Whatever investigation you have to do, you do in the first few days, and then let the man be sent to jail, and let him then apply for bail if he can get it. Or if he can't get it, he at least stays in jail and waits for his trial. But keeping him in police custody is very unfair, because a lot of things, wrong things are done in police custody which don't come out in open. They are basically police, the old habits will never die. Police has been so harsh and this whole culture is so anti-citizen and anti his rights. Because don't
As a
forget
judge,
that,
did you come across some instances where the police had misused the power of remand that was given to them?
well, see, those remand cases don't come up to session judges and high court judges. They stay with the magistrates.
Okay.
I would always tell the magistrate, please don't be lenient in giving remands. You must see the case diary. You see, the investigating officer has to maintain a diary,
Right.
and which is confidential, fine, but he has to keep it up to date. So for a case diary, he should see the case diary and actually see for himself whether there is a case made out for a further remand for investigation, or the man should be sent to judicial lockup instead of back to the. But there's so many wrong things happen. You see, the FIR registers are not completed for days. The daily Roznamcha is filled up after many days. So that gives them time to fabricate and cook up stories. This may not happen in large metropolitan police stations, but in the remote areas, all these things do take place, and the poor accused doesn't get doesn't have much hope that he'll get justice.
Right.
That is where the problem is really, not so much in Delhi or Chandigarh.
The human rights activists are also crying foul on the fact that the sedition clause has not only been retained but has been rebranded and its scope has been widened. They refer to section 152 of the BNS, where they say that more activities have been added to its purview. How do you look at this aspect?
I mean, that is true. They have done it. But now if you have a strong judge, a strong trial judge, then he will see that no miscarriage of justice takes place. You see, you got to prove the case beyond reasonable doubt. And until that is done, the accused is presumed to be innocent. So these things have to be always kept in mind, that man produced before a court is actually innocent. He has to be proved guilty, and
Right.
proved guilty through proper evidence, and not proved guilty in TV chat shows and the media trials. That is rubbish. You see, don't. It means nothing. He has to be proved guilty on the basis of evidence, legal evidence collected legally and produced before the judge.
There is also a feeling that this would give police much more powers, and some people especially refer to section 113 of the BNS, which incorporates terrorism, which is already covered under UAPA, Unlawful Activities Prevention Act. So how do you look at this duplication? Do you think it will give more powers to the police, and police could end up misusing these, and in a way, a kind of a police raj could come about in places?
You see, the colonial era was a police raj. And after that, the police never got out of the habit of using their powers in an illegal way. And that has not stopped. There is nobody to stop the cops to, follow the legal route. They always misbehave with the accused. They're hardly helpful.
Right.
And you're right. Well, if some offences have been added, it's unfortunate, but judges should be strong enough to see that this particular offence has not really been made out. I mean, you can add any number of sections, but if the ingredients of the offence do not exist, then there's no way you can convict the person.
Justice Garewal, you've been a votary as a judge of a strong criminal justice system, and you've been saying that the executive and the police should be out of this criminal justice system, except for the power of arrest and the initial investigations.
Yes.
How would that work?
So it is like this. Now, the example is that we are traveling from Chandigarh to Delhi. So this is the super highway we are traveling on. So the investigator takes the accused up to Ambala. Then he hands the baton to the prosecutor, who takes it from Ambala to Karnal. Then he hands the baton to the judge, who takes him to Delhi. So this is a very smooth system where it's compartmentalized. They work as a team, like a relay team. So after you've done your job, you run your 100 meters, then you pass the baton to the next runner,
Right.
and you drop out. So this is not happening. See, the police dominates everything, and there's way you. How does the poor accused defend himself? It's the police is so strong and powerful, and it is all the district magistrates, the SPs, the ministers, the politicians. They interfere in the investigation, and there is no protection for the accused. The protection would be from the prosecutor. The prosecutor is strong. He will tell the police officer that, look, you've done your investigation, thank you very much. He will now examine and see actually if the accused is got, if there is strong prosecutable evidence against the accused, then we will take him for trial. Otherwise, why waste court's time if he's going to finally get acquitted? It's also wastage of judicial time and resources.
So are you suggesting, Justice Garewal, that we should have a new criminal justice system, a new CRPC, a new code?
Well, I'm not really suggesting a new code, but a new way of doing things. There should be, now for instance, I have not checked up in the new code. In the old code, there was a section which said that the state shall lay down the powers and functions of prosecutors. They have never done it. So earlier the police prosecutors were sub-inspectors. Now they are additional public prosecutors.
Right.
And but they are still too junior. You see, you can't withstand the SP. The SP wants to fix somebody. Then the poor assistant public prosecutor is too junior a person. What we need is, like you have the advocate general, we need a prosecutor general who is independent.
Okay.
And who is strong, powerful, independent, who enjoys a big status, high status, like a high court judge.
Okay.
And who's in charge of prosecution, and whom you can catch. If the prosecution fails, then somebody is accountable. It should be the prosecutor who is accountable.
Right.
Why was the man prosecuted if the prosecution was going to fail?
Justice Garewal, you worked in various places, including the United Nations. Which is the system? Which country has a system which is akin to the kind of system that you're talking about?
So, England, in the United Kingdom, you have a prosecution service. Like the police service, you have a prosecution service.
Okay.
And they take care of prosecutions, you see. And then you have, of course, the courts. So the prosecutions are very strong. They have the powers. They have the powers to drop charges also. If they feel that charges are false or not sustainable, the charges are dropped. Finished. End of the story. So they are strong enough, and they are reliable. They are honest. They have high integrity, and they realize that they don't want to waste time of courts and the time of the money of the taxpayer in wasteful prosecution.
Okay. Now, Justice Garewal, my last question. Since the new laws have been introduced from today, they'll be functional. I believe in Delhi, the first FIR also has been registered under the new law.
Yes.
So how should concerns raised by people like you or others, should they be addressed? You think the Supreme Court should take suo motu notice, or hopefully somebody will file a PIL? How should we go about it now?
You see, it will be better for the Supreme Court to sort out all the little creases right in the beginning. Otherwise, it will keep getting more and more complicated. The courts will keep getting clogged with petitions in the high courts challenging some provision or the other, and different high courts have different views, and you'll have people going to the Supreme Court with SLPs, and in the meanwhile, the basic trial procedure will get neglected. So they'll all be going along the by-lanes. They will not follow the straight highway expressway to Delhi. They will just follow the side lanes and the by-lanes, which is already happening under the old law, but it will increase, which will be... So, yeah, Supreme Court, if they are able to take a holistic view once and for all, because really there was no debate in the Lok Sabha.
But on first look, Justice Garewal, it appears there is reluctance to intervene. I believe a PIL was filed in May, which was not entertained. And some judges have even appreciated the laws as a watershed moment in Indian justice system. The Bar Council of India has sent out messages not to protest for the time being, because this issue is being taken up with the government. So how do you look at all that?
That is true, sir. This is what we have. We have to face this. And unless, you see, the judge cannot really give an opinion until there is a concrete case before him, and which demonstrates how there is a defect in the system. So unless that is shown to him, it's hard to comment. But it's unfortunate that such a shoddy job was done. It could have done a much better job with the intent. For instance, I'll just give you one little example. That under the 1898 CRPC, when a man was arrested, he was produced before a magistrate within 24 hours. Because at that time, it actually took 24 hours to get to a magistrate. But the same provision is mentioned in the Constitution, 24 hours. It is mentioned in the 1973 CRPC, it's 24 hours. Why do you need 24 hours? A man is arrested in Sector 17, he has to be taken to the police station. Take him straight away. It won't even take 24 minutes.
Yes,
so why 24 hours? And this is a time that the police takes to, make up things. Because police is inefficient. They can't get things ready on time. And so they take him here and there, and then 24 hours is required for... it's sad. And this is one reform they could have done. They should have reduced this to 4 hours.
Sure. Thank you, Justice Garewal, for sparing time and being with us. Thank you.